Here live. All right, we're back in Senate Judiciary on April 30th. Doing the walkthrough / markup of 772. We have Ledge Council here. Floor is yours.
Good morning. For the record, Cameron Wood, Office of Legislative Counsel. Still looking at draft 2.1 of 772. I believe it was yesterday morning, we kind of walked through some of the changes that you have here. And based on our conversation, I didn't have any changes to go back and make immediately at that point. There are a few minor language words, phrases that I'm going to connect with Michelle Childs on. If you remember, I mentioned there's the word perpetrator used in the bifurcation of the rental agreement, and I wanted to check on whether that was the correct term of art to use in that context. And so I'm going to connect with her today. So I may have a few minor language tweaks to make, based on the next version when you want to take this back up, but I haven't made any changes based on our conversation from yesterday. And I think, some of the pieces, I'll share my screen and pull the document back up just as a quick reminder. Some of the changes that we were discussing were in the termination section. Terminating a rental agreement, we were having a conversation about this change in the subdivision B2. It was ongoing and repeated threat. Now it's ongoing threat. There was discussion there. And then there was also some discussion about, is it appropriate to use the term protected tenant here on page 8? Can it just say tenant? And so I've had done a little bit of reviewing. I was going a little bit back and forth of whether protected tenant or tenant makes the most sense in this context. I was leaning towards protected tenant, but I did communicate with the network and they're okay with going with just tenant in this section. And I agree that I think that that's okay. If you want to just reference tenant, you're opposed to protected. I don't think there's any legal concern with going that route. And it would make the section read correctly if you did that. But again, it's a policy decision for you all of whether or not you wanted to say protected tenant because that's the term of reference below. Sorry, Rosie.
So what I'm understanding is from a policy standpoint, tenant versus protected tenant doesn't really change anything, but protected tenant is clearer because that's the language used elsewhere.
It could be. On page 2, you have the definition. Protected tenant has the same meaning as section 4471. It's 4471 exclusively limited to protections around stalking, domestic violence, etc.
So as we talked the other day, I'm just pulling it back up so I can reference back to it. Imprints. Yes, sir. Unfortunately, when you look at that subchapter, the current section of what they're related to is it gives protected tenants the rights to terminate rental agreements when there are instances of domestic abuse, sexual assault, stalking, etc. It gives them the right to request changes of the locks of the dwelling units, and then it has confidentiality provisions.
And then all of those are referred to as protected.
In that subchapter, there's a definition of a protected tenant, and then it's used throughout that subchapter. And protected tenant is defined as a victim of abuse, sexual assault, stalking, or parent, foster parent, legal guardian, caretaker with partial physical custody of the victim. So that's the term that's used throughout. And as I mentioned, I'm adding in the section down here in subchapter 4 to authorize the bifurcation of a rental agreement. So when you look at that section on page 14 of the draft, it has to refer to protected tenant because that's the language that's used in that subchapter. So then it just becomes a question of up above in the residential rental agreement subchapter, what is the proper term to use? And It does become somewhat problematic from a wording perspective when you use protected tenant on this page. Because, for example, it says a protected tenant who is the victim, I'm looking at sub B here, right? Protected tenant who's the victim of domestic abuse, sexual assault, or stalking. Well, a protected tenant is already defined as a victim.
Yeah,
So it just, there's a little bit of language gymnastics that you kind of have to go through. And if you want to keep it as protected tenant, I would probably have to clean this up slightly to make those words fit properly. Ultimately, you could also just say tenant, and then you could, as it is, you know,
Well,
a tenant who is the victim.
in other words, it's defining it here without the word protected.
Correct, you would just be referring to any tenant
But then it's who is,
who is the
and it
victim.
essentially gives the definition again.
Yes,
So in that case, it matters if we go with tenant.
so we're protecting that,
No, with tenant in the section at the top.
this one.
Yeah.
I mean, as I mentioned the other day, I mean, this section here, the subdivision 5, it's intended to identify that a tenant who is the victim of an incident of domestic abuse, sexual assault, or stalking cannot have their rental agreement terminated because they're the victim. And then it's in the B here, it's signaling in this section. You have to authorize someone to bifurcate the rental agreement as the section articulates down below. So you can use protected tenant again to just kind of be consistent in the two sections. I don't think that there's a problem with that. You just may need a little language cleanup if you want to go that direction. There was a concern about whether or not, as we were discussing last time, there was a concern about whether it's appropriate to use protected tenant. And I'm letting you know, I have to, but you can.
So, Charlie, not to put you on the spot, I know this is language that is, I believe, originated from the network, right? You want to provide a perspective on what we're discussing here? That might be helpful for us.
Sure, I'm happy to. Charlie Glisserman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I have reviewed this language, and I do generally agree with Cameron that the policy impact will be the same. If you look at the definition of protected tenant, the only thing that is different from just listing a victim of abuse, sexual assault, and stalking is that there is a second line that says, I don't know, Cameron, if you're able to pull it up. Thank you. A parent, foster parent, legal guardian, or caretaker with at least partial physical custody of a victim of abuse, sexual assault, or stalking. So that was the question that I had. If protected tenant is changed to tenant, would that second list of folks be properly covered in the lease bifurcation? Because in the civil definitions of abuse, sexual assault, and stalking, it does often reference household and family members within those definitions. I think largely you would be covered if you use tenant. So to round it out, I don't think there will be a significant difference between the two. I personally think protected tenant is clearer, but I don't have a strong preference between the two. I think if the committee is agnostic about it, perhaps using protected tenant might just be the clearest and most comprehensive option.
So would that be, Charlie, protected tenant and in those sections, who is the victim of blah, blah, blah?
I mean, I would defer to legislative counsel. I don't know if that language is needed if the reference to protected tenant is used.
So it seems like we could go either way, but just eliminating if we use protected tenant, we just eliminate some wording in the next draft.
So would it then just be protected tenant as defined in that other place in statute?
Yeah.
I will clean it up slightly and bring it back to you. So if you want to go with protected tenant, then we'll make sure the language fits, the words fit as needed.
Okay, let's just stick with the protected tenant for now. If for some reason, that changes, then I do, did they say what time they're, 10:15, okay, until.
And then the other major change was adding that study at the end. I don't know if you all have had any thoughts that would be hopefully towards the end of testimony from yesterday.
Rather than study, when we go to the trespass section, because I know we spent a lot of time on the bifurcation and the expedited hearing. I don't know that we've had as in-depth a conversation on the trespass piece. And it's back to their questions or recommendations on the committee. That's on page 20. Yes, sir.
So just as a quick reminder, you have section 4, which is a purpose statement stating that the purpose of the next section is to overrule the Supreme Court's decision on State v. Dixon, allow the landlord of the dwelling unit to issue no trespass orders, which would prohibit a tenant's invitees or licensees from entering the dwelling unit's common areas under certain circumstance. Then you get to section 5, which is the unlawful trespass section in Title 13. And you have an addition of a G1, which says that the landlord caused to be served an order against trespass to prohibit the invitees or licensees from trespassing in the dwelling unit or the common areas if the tenant consents to the order, the invitee or licensed subject to the order has violated the terms of the lease agreement, or the invitee or licensee has violated state or federal law while on the premises. So that's the description.
Did they get on the first?
I do, and so, it's, my question is around what constitutes consent. Could it happen that a landlord puts in the lease that by signing this lease, you consent to this type of no trespass, or would they have to actually have a conversation with that person about the individual in question?
I think if the lease agreement said something to the effect of you by signing the lease consent to the landlord issuing an order against trespass to anyone who's violating the lease terms or breaking, violating state or federal law while on the property, and that would probably be how it would be phrased. I don't see any reason off the top of my head that would prohibit a landlord from doing that. I think the question would be, is the tenant consenting at that point? Probably. I would need to do a little legal research to see if that would be upheld in court or if that would be some sort of illusory provision of the contract, but I think it's deeply pathetic to do that.
I'm on the purpose section on page 20. That says the purpose of section 5 is to overrule the Vermont Supreme Court's decision and blah, blah, blah. I've never seen that before. And I guess what I'm wondering is it accurate to say we're overruling them? Because they're the Supreme Court. So it seems like only a higher court can overrule them. I mean, we're in effect using our authority to move around their decision, but it doesn't overrule their decision. Is that right?
It does in some sense. So the Supreme Court case in question, State versus Dixon,
Yeah.
it stated that there's a common law rule that the tenants who have lawful possession of the dwelling units.
I'm not even talking about the substance.
Mhm.
I'm just talking about the relationship, separation of powers, basically, and how to refer to it. So we're looking to make statute that avoids their ruling, or I don't know. Just I have never heard of the legislature overruling the Supreme Court. Like, they can overrule us because they issue rulings. We don't issue rulings.
Right, it's what I was getting to, and my colleague Eric Fitzpatrick drafted this.
Yeah.
It was a House bill, it was a separate bill that was introduced and then was brought into 772 on the House side. So I would potentially defer to him on the specifics of why he chose to use that phrasing, but I will tell you that my understanding here is the court's case was based on common law. And if you all, as the legislature, want to overrule the common law with statute, you need to be very explicit that that is what you are doing.
But I would argue then we're changing statute around common law. We're not overruling. Anyway, maybe it's just too much focus on, like, I would react the same way if we said we were overruling the governor's veto of something. It's not really overruling it, it's, you know.
But I think in this context, you are overruling it in the sense they base their decision on the common law and you're saying, okay, that's what the law is based on the common law. We're overruling that law with this statutory provision. You make the law different based on what we're putting in statute.
Okay. Yeah, I'll talk to Eric about it. I just think that's just feels provocative to me when it comes to this, the high court. Like, I've just never heard that way of expressing how we might go around one of their decisions or get what we want in spite of their decision. Because ruling or overruling doesn't seem like what we do. We legislate, they rule on the decisions. Anyway.
I have now drafted up similar provisions, so if the term of art or using the proper term, again, I would probably defer to Eric on that piece because he's the one who initially drafted it up. But I do know that you need to be very clear if you're wanting to alter what the court has stated here. And so I do think that you are, in a sense, overruling what that decision was.
But like with the governor, we override, right? With the, I just don't. Yeah. Anyway.
I see your point in that we're not really saying, no, the court got it wrong. We're saying, sure, that's what you made based on this law, so we're going to change the law.
Exactly. It's just not overruling.
Yeah, I do hear you. But I also feel like I've heard that terminology used before. I feel like miscellaneous ag did it actually with the emu farms.
Everything comes back to the.
Everything comes back to emus.
We can revisit the purpose section of that. We're not too stuck on it, but the, going back page 21. Well, did you have more to share initially? I know we started taking questions regarding the purpose, but did you have any other information you wanted to raise first?
I know there's a concern that has been raised about a specific provision and how this subsection G would work in practice. Mr. Chair, if you want me to dive into that.
Yeah.
Okay. So, there was some separate language in the new subchapter in a previous version. So if you remember, as this came over from the House, it had a new subchapter about ejectment. And you've removed that new subchapter in this draft to just go with a new section for the expedited hearing for threatening behavior. One of the provisions that was removed in the previous version was a section that authorized a landlord to issue a no trespass order to a defendant in an ejectment action when the landlord received lawful possession of the property. So you get rid of possession, you're restored to lawful possession, you can issue a no trespass order to that individual not to come back on the premises. And there was some concern about that section being removed and how it interplays with the language that you have here on page 21 with subdivision G1.
So just to uh, lay out the scenario again, just to make sure that we're all on the same page. Talking about a situation where tenant gets ejected. At the time they're getting ejected, the landlord also says, by the way, here's no trespass order, you can't come back. And then another tenant invites the former tenant back in. Just the question is, what happens there?
Yes, right. Exactly. That is the scenario that we're kind of discussing here. And my understanding from the advocates and the testimony they've given is they were seeking the ability to issue that no trespass order at the point of ejectment, and for that individual not to be able to come back on the property, even if they've been invited back from another tenant. And as I dug into this, after the concern was raised, the issue is that's the exact scenario that the court ruled in State versus Dixon. Individual had been issued no trespass order. They were invited back by a tenant, and the court ruled, the common law says the individual has to be able to go to the common areas to get to the dwelling unit where the tenant who has lawful possession of the property invited that person. This subsection G1 was intended to address that, but it says that you can issue the order against trespass if the tenant consents or if the invitee or licensee has violated the terms of the lease agreement, or the invitee or licensee has violated state or federal law while on the premise. One of those conditions has to occur first before a landlord would be able to issue the trespass under G1. And so the issue came up of the scenario you've identified, tenant gets ejected, another tenant invites the person back on. The person comes back, they're going to have to violate the lease terms or violate law before that trespass order that they were issued when the ejectment happened is going to be upheld in court, correct? And as we dug into it, and as I read this language, I think the answer is yes.
With the way it's currently written.
The way it's currently written. So I think the concern from the advocates would then be, wait a minute, we eject someone, we don't want them to come back. Issue is you have to balance that with the fact that they've been invited back by a tenant. That's the issue under State v. Dixon. So G1 says, even if they're invited back, you would still have to wait for them to violate a lease agreement or violate state or federal law. And I think the advocates are concerned about that because they want to be able to prohibit that individual from coming back once they've been ejected. They don't want to have to wait for the person to come back, continue to violate law, to then have to be issued another order for it to be upheld in court. And so if you want that to be the policy, then the recommendation that I have would be adding in a subdivision D to this section to allow a landlord to issue the order against trespass if, so it would read, if the tenant has consented, the invitee or licensee has violated the terms of the dwelling unit lease agreement, or the guest has violated state or federal law on the premise, or if the invitee or licensee has previously been ejected from the premise under an ejectment action that's brought under Title 12, Chapter 169. So I think you would expressly need to add in that this section is intended to cover a no trespass order that's been issued to someone who has previously been ejected, because that's not what the language says.
There any issues around freedom of association? You know, if somebody, a tenant in another dwelling in the building wants to associate with somebody who was previously ejected. Any thoughts on that? Or is that kind of not your man?
No. I think it's a question, an open question, I would argue. I have not found a court case that, or, guarantees the right of a tenant over an objection of the landlord under, say, the First Amendment. They have a constitutional right to have their own guests on the property. That's not what State v. Dixon says. The court case in State v. Dixon is not based on any constitutional right. It's based on common law. And not aware of any other cases in other jurisdictions that would guarantee that, you know, a tenant has a First Amendment or, you know, other constitutional right to associate that would override or overrule a landlord's property rights to exclude individuals that wants from property that they own. But it's also not, you know, again, I haven't found a case, so I haven't seen any argument made. So could the argument be made? I think so, where a court would land on that. It, you know, it's going to be a court looking into that analysis. But I do think that is one of the concerns that has been raised by the advocates along this process is you are, you know, you're giving the landlord some ability to exclude individuals kind of against the tenant's will. If you want, just the tenant wants to invite these individuals on, and you're giving the landlord the ability to exclude those people from the property. It has to be one of the conditions that are met. Violating lease terms, violating state or federal law, or again, having previously been ejected from the property. But that's the arguments that would be sent to those meetings.
I have a couple of questions, two of which I'm pretty sure are firmly in your wheelhouse, one of which may not be. But first one is there a difference between eviction and ejection? And if so, what is it?
The answer I have there in this statement.
Okay, so they're synonymous terms. I've heard one used in some places, the other used in the other, and I just want to know if we were talking about different things. My second one would be if we added the language that you're talking about, would that be forever? So someone was evicted 10 years ago, has gone to treatment, meets someone and is dating someone in the building, and they can be no trespass.
Does it have to be renewed every year?
Well, I think the no trespass does, but if the language as proposed says they can be no trespassed if they've been ejected from the premises,
There's no time.
there's no time limit. So the landlord could no trespass them at any time. If they have ever been.
There is no time conditions on the sub G as it's currently written. Trying to pull up the trespass section to see if there is anything in 3705.
And the date on this one?
Yeah.
Although, Cameron, just so you know, in a minute or two, we're gonna pivot to another witness for a few minutes on the Zoom, then we'll see what happens.
Let me look at 3705, but there's nothing in sub G, so I think to the point, if you had previously been ejected 10 years ago and you were issued the no trespass for the property, presumably that's going to then last.
Okay. And then my last question, which may or may not be for you, sounds like the chair might have the answer, is around those no trespass orders. And if they are time limited, do those have to be renewed every 6 months, every year?
There's a difference between if it's public versus private property, I think. And for one or the other, I can't remember which, it has to be reissued every year. I believe, I can't remember off the top of my head.
I don't recall being a reissue requirement in 3705, at least for private property, but I will, let me look into it and maybe look at it, so.
Okay, all right, so we'll take a break from this for a moment, see how long the next 10 is we may come back to it.
Step out. Emery, if you don't mind letting me know as soon as the committee potential wants to come back. And
Thank you. We're gonna switch gears back to miscellaneous. We have Big Hartman from the Human Rights Commission. I believe they made a request to Senator to speak for amendment. And morning, Big. Can you hear us?
We can't hear you.
Okay, can you hear me now? Great. Thank you so much for taking some time to talk with me today. I'm sorry I'm not able to be there with you in person, which is always my preference. I believe the committee has the language in front of them. Is that
Yes.
right? Okay, so I'll just give you a little bit of information about this, and I'm happy to answer any questions that folks have. this section of the bill would be really an administrative change affecting a small portion of HRC discrimination complaint investigations. And that is cases that the Human Rights Commission is lawfully empowered to initiate ourselves. So we are a government agency committed to advancing full civil and human rights in Vermont, and our enabling statute authorizes us to initiate complaints, although of course the vast majority of complaints that we investigate are brought by individual complainants who believe they have been discriminated against. Our office conducts impartial investigations of any complaint that we accept for investigation. And in general, we are fairly constrained by Section 4555 in Title IX with regards to the confidentiality of our cases. Now, I want to make clear that our confidentiality provisions apply to our disclosure of information related to our investigations and not to the parties' ability to disclose information related to investigations. But the confidentiality provisions that we currently have do severely restrict our ability to make our findings and the basis for our findings known to the public. So, but in a standard complaint that is not initiated by the HRC, what the parties want to do with our investigative materials and our investigative reports is really up to them. We do use this tool that enables us to initiate investigations ourselves, not infrequently, but it is a tool that is very important for certain types of cases that we want to investigate, particularly those where there's a broad issue, a bigger issue than like individual disputes that might impact a larger segment of our community or our population. Sometimes we also have issues with complainants not being able to come forward for a variety of reasons. Individual complainants who must sign and notarize a complaint sometimes are reluctant to initiate a complaint with us based on their fear of retaliation, or there may be other obstacles to their ability to actually get a signed and notarized complaint that are but they are still reporting to our office information that we want to investigate. And so we do have the ability to initiate those investigations ourselves, and they tend to be related to issues that have a larger impact, public entities or other larger entities operating in the state. So this is a tool that we intend to use more and more, especially given that the legislature has taken it upon, has gone ahead and expanded our capacity in recent years. We've had additional litigation capacity for our office, and we've increased our investigation capacity in recent years. And we've also seen the legislature expand the laws, the anti-discrimination laws that we enforce. So we take those changes seriously, and we want to continue to advance full civil and human rights by having, more opportunities for HRC initiated complaints. And our concern is that when we are operating under the same confidentiality provisions as cases that are initiated by individuals, there really isn't the transparency that I think is an option in other types of investigations, because as the complainant, member of our staff is not able to disclose the outcome of an investigation or the investigative report under today's, law. So this, small addition to the confidentiality provisions of our statute that I believe you're looking at today would enable us to disclose the investigative report and the determination as a matter of public record in those cases. Of course, we always are required to engage with informal conciliation and attempt to work out cases that we're investigating. But when we're not able to do that and we end up with an investigative report based on a complaint that we've initiated, we feel that this is a unique situation that benefits the public and the public's interest in seeing civil rights enforced to be able to make those findings public.
Thank you. Committee, any questions? Thank you. Senator.
Yeah, big. So I understand the current law does not allow you to do this, and I'm all about the transparency aspect of it. My question would be, so this just gonna be commonplace now that in all of these cases that you start an investigation on, they'll be released entirely, or you gonna pick and choose which ones will be released or not be released?
I believe the bill, and let me just pull it up real quickly because I have seen a couple different drafts. This makes it that any investigative report that we issue a final determination on will be can be public. It can be available to the public after the determination has come out.
Okay.
Just to clarify, did you say that the report will be public or can be public?
Let me just see what the language is.
The
It's
language-
available. It's available to the public. So that means if I got a public records request, we would be able to share that with the requester, which
Okay.
right now we do not do
So
per the
you
confidentiality
can-
provisions.
So you wouldn't be picking and choosing what to publish, but you would have a database. And if a member of the public says, I want this report, you shall make it public, right? Is that what it does?
I believe so, yes.
Okay.
That's correct.
So just one more question on that same line, Big. So are you saying that you would not release any results unless the public had requested?
As we currently handle our determinations, we don't have a practice of posting any determinations up online at all. And we only generally disclose determinations when they're requested by a party.
All right, thank you.
So I wouldn't see that practice changing drastically either way.
The bill language as drafted, so this is page 1, line 15. The commission shall make any resulting investigative report available to the public after it's issued a final determination, etc. Shall make means that if the commission received a public records request, they shall make it public. If there could be some other public records request or Public Records Act protection applicable to part of the investigative report, and that would require some protections. This doesn't notwithstand everything else that's currently protected under law. So that is one element that could be at play. But if the commission receives a Public Records Act, this requires them to make it public. As drafted, it allows the commission to also separately from a Public Records Act request, make it available in some way. I think it sounds like from the testimony that the commission has a practice related to that. As drafted, the language would allow the commission to do that. So policy decision for the committee, if any of the questions stem from a concern or desire to handle that differently, that's a function of the language, and there's a way to craft language to only be responsive to a public records request or not, depending on what the intent of the committee is.
But as it's written now, it is only responsive The public record request?
Correct. So it means that if you get a public record request, the commission has to release it.
Right.
Not, subject to potentially other protections. And if the commission wants to release it or wants to make it available, the language as currently drafted would let them do that, apart from a public records act request. So there's a difference between what the commission's practice is related to that versus what the bill language would allow. And as drafted, it would allow the commission to do that.
So that would kind of go to the concept of discretion of the commission being able to publish something without a record request being made, right?
That the commission, it doesn't specify, because it allows that, but the language doesn't necessarily require. Because it's available to the public, that's the key language here. That's giving some flexibility. If it's shall disclose, shall make public, that's the has to release it. This Public Records Act is also a specialty of someone else in Legislative Council. And so to the extent the committee is interested in refining this, I think I'm happy to take what the committee intends to cover and then work with our Public Records Act specialist to make sure that the language is affecting that intent.
Thank you. Big, I know you have to go here in a moment, but my last question here. It's my preference to make there be less discretion on part of the commission, because I think that could potentially be problematic. I would rather it be a streamlined system where, regardless of what the record is, that if there's a request, it shall be made public, rather than if there's a request or if the commission chooses or cherry picks. I'm not saying that's what you would or wouldn't do, but I would prefer a streamlined process. In the 30 seconds you have left, can you share with me your thoughts on that?
Absolutely. And I think that that's, a policy decision for you all to make. And I think if you wanted to make it more clear for us that you want us to put these investigative reports and determinations like up on our website, that is something we will absolutely operationalize. We don't have that built into our processes right now, partly because of, having an old website and being, and the bandwidth issues of, having to update that every month with new cases. But that is something we could absolutely do if it directed to. And I also just wanted to mention that not all cases result in investigative reports. Cases can be dismissed during the investigation. If we find that there's not a prima facie case of discrimination, we do need to dismiss that case under 4554. And if cases settle, if there's a conciliation, then before an investigative report is done, then that is by law a matter of public record, that conciliation agreement. This is going to be a pretty small subset of our work where we initiate an investigation and complete an investigative report.
Senator Bohosky?
Yes.
If you have time.
Well, to the chair's point, and I did say this, but everyone wasn't in the room. Initially, this amendment did include a requirement that the HRC put these in a database, much like the Criminal Justice Council does all the work they do. Through conversation with them, that felt like a bigger lift than was possible in this amendment. And we have agreed to look at that more and come back with that next year. So we did agree with you that it should be much more streamlined and that building that database and the requirements around that database were a little more intensive than should go in the miscellaneous judiciary bill. So we made the administrative change to say you need to release these with the commitment to coming back next year with legislation around that database.
And probably with personnel requests.
Potentially, and that was some of the stuff we wanted to do. So the Criminal Justice Council has a database that they put all of this forward. Some of it is redacted, some of it is based on the laws, but there's a database there and they are but the Human Rights Commission at this point doesn't have that. And so we didn't feel like that belonged in a miscellaneous bill, but that we needed to do the digging. Would this require a staff person? What would the rules around what gets put where and how be? That felt bigger than miscellaneous judiciary.
Thank you.
And I'll just add on to that, that the draft I had looked at about that database was about complaints, and that's a lot broader than our investigative reports here. I absolutely look forward to having that conversation in the next biennium about ways that we, as a state want to improve the transparency of our investigations, because, it's a very strict confidentiality standard that we operate within. So I can't even tell you whether there's a certain investigation underway, because all complaints are confidential. And they only cease to be confidential if they fit the current requirements within confidentiality provisions, which is a public settlement agreement or a determination of reasonable grounds. And then it's just the determination and the party names at that point that are allowed in the public record.
Thank you.
I really thank the committee for taking the time in this busy week to consider this provision. And I look forward to conversations next biennium about, other improvements we'd like to see to the Human Rights Commission statute.
Thank you.
Thank you.
Committee, unless there's any objection, I would like to make this a bit more clear as to that, if there's a public records request, then, what's covered here will be made public, rather than being unclear as to, is this all getting posted on the website in some database? Do they have the ability to pick what they're publishing? I think that it's better generally to provide the blanket requirement that the record request can be made public. Any objection to that?
No, I go along with that. I think it's better. Yeah, it takes care of my concerns as far as what they hold. So for transparency purposes, and facts and throw a FOIA request in, then yeah.
If they can't say whether they're investigating something or not, how would anyone in the public make a public records request about an investigation they don't know is happening?
Well, it's not ongoing investigations. It would be investigations that are concluded.
But how would they know it was concluded if it hasn't been made public and nobody in the public knew it had happened?
Without being a Public Records Act expert, I think there are two scenarios. One, if a final determination issues, then, and that happens if the commission has found there are reasonable grounds, then a member of the public could know that an investigation had occurred and could request the investigative report attached to the final determination. I think the other scenario is, as the executive director described, if it is the kind of cross-cutting or affecting a large segment of the population kind of issue. In some cases, it's plausible to think that the public is aware of it through media or other things. Sometimes Public Records Act requests are looking to see if there is something without knowing if there is. But it is a point that the commission is not disclosing what they are investigating. And so there's nowhere that someone in the public could go to look to see, here are the possible HRC investigations that might have resulted in investigative report that I can request. But if you want more Public Records Act details, I will have to.
Who was the alleged counsel for that?
Becker Anderson was generally.
So we'll move forward with that for now, and then we'll talk about see if there's any additional information for him. But I think if we can stick to something, if we can move to something that's a bit more specific where the public records request, that would be the most. That's,
You'll be getting,
my brother. My son. Thank you. Okay. So we gotta go to Eric. Eric's not in here. Actually, I can go find it. We can take a brief.